their phone with what they charge. I would send them allocating partial, part of it was business, part of it was personal. Great, thank you.
We're ready.
Okay. Jocelyn, are you ready or not? If you need more time, please. Are you okay? Okay. All right. I'm going to call to order and open up the special magistrate hearings. It's a bit after 9 a.m., Wednesday, June 21st, 2023. What I'm going to do, as always, is give an opening statement of how these hearings will occur. If you've been here, you know how they occur, so it may sound redundant, repetitious, so you'll have to just bear with me. Thank you for being here, ladies and gentlemen. If you could please turn off all cellular telephones to avoid interrupting these proceedings. Also, to be emphasized, there are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the magistrate, we ask that everyone show mutual respect for one another by listening quietly and patiently to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts or attacks, verbal attacks in favor of or in opposition to the speaker. These are hearings conducted by the special magistrate, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I'm the assigned special magistrate for today to hear today's cases. My responsibility is to act like a fact finder, analogous to a judge, but keep in mind I'm not a judge. I'm just a fact finder, a special magistrate, to determine whether or not there are violations that have occurred on your property and determine whether or not you've complied with any attempt to remedy them and the like, and to hear the evidence, the pros and cons of why you should be found guilty or responsible for the alleged violations presented by the alleged violators. These hearings are obviously open to the public. It is required that all persons who testify to the facts of the case be placed under oath, including the code enforcement officer, which I'll do after this opening statement. Keep in mind also that since I mentioned that we're not in court, or I mentioned that I'm not a judge, we're not in court, we're not in circuit court, we're not in county court. The regular or formal rules of evidence relating to evidence and witness testimony and documents do not apply. Any relevant evidence will be considered and admitted if I find it to be competent and reliable, regardless of the existence of any rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. If you refer to it, be prepared to put it into the file. If you need a copy, staff will give you a copy of what you're referring to and what needs to be put in as an exhibit, so there's a record of the proceedings. Also, no documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Again, my policy is that if you refer to it, you give it to the city to review, it becomes a public record, and it needs to be put into the public file to be part of the record. Each party has the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination. Also, to impeach any witnesses, regardless of which party first called him, to testify and to rebut or refute the evidence against him. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is presumably but rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties or fines, to issue orders having the force of law to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is what is called substantial competent evidence that the named violator was responsible for a violation of the relevant section of code as charged. If I affirm the decision of the code inspector and officer, my order will specify the amount of the civil penalty, the administrative costs of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the city, may appeal a final order of a special magistrate to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the magistrate. An appeal shall be filed within 30 days of the issuance of the order sought to be overturned. What that language means, as I read it, is that whatever you present here is the record. If you decide to appeal, which you have a right to do, it goes to the circuit court with a filing fee. You'll need a transcript. You'll need to have a court reporter type up the minutes from this public record, which can be done, but it becomes costly. And that's the record, as well as any documents that have been admitted or referred to, and evidence would be part of the record. The circuit court, if there's an appeal, is not going to rehear the evidence again. It'll determine whether or not there's substantial competent evidence that was found by the magistrate in this tribunal. If you are found guilty of this civil violation charge, you will be assessed an administrative fee of $100. As part of the scenario, the city representative, code officer will present their case first, and the alleged violator will present their case thereafter. I'll consider the evidence and render a decision after all arguments are heard. At that time, I'll listen to what the city has to say as to how much time you have to comply before a per diem or daily fine begins to accrue. And that can be anywhere from 5 days, 10 days, 30 days, 60 days, 90 days, depending on how difficult it is or what you need to do and the facts and the like. So there's going to be no per diem that will begin to accrue until after that time period. And those are basically the ground rules that occur. Again, after the city presents its case, you'll be able to, and I've said this before, but just keep in mind, diplomatically and respectfully, professionally, and then I'll render my decision thereafter. At this time, I'm going to swear in all witnesses who will testify under oath. If you're going to testify, please stand and raise your right hand and repeat and affirm. If you can't stand, just stay seated, but raise your right hand. Okay, thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If you could please affirm. Okay, at this time, before we have roll call, I'm going to, whatever minutes that I need to adopt, you have special magistrate hearing minutes, April 17th, 2023, I'll adopt those, and May 17th, 2023, I'll adopt those as well and sign off on them. At this time, we'll have roll call as to who's going to testify from the city. Thank you very much. And any other staff of the city. Go ahead.
Chief Code Officer Joseline Ramirez.
Brian Sherman, interim city attorney.
Harry Hippler, special magistrate.
Nasli Cardona, code clerk.
Mary Curry, building clerk.
Okay, any adoption of the agenda, deferrals, additions, modifications? Great.
Yes, I would like to remove case 73 286. They have complied, and the case is closed.
Okay, great, good.
And I would like to add one case 7182, for an abatement of fine.
Okay, 7182, and you'll call that when necessary, and whether there's an agreement or not. If not, then we'll hear it as is, whatever you have. Okay. And that's it?
That's it.
Okay, thanks as always for your help and your diligence. I'm going to defer to the city as to which cases to call. Are there any attorneys in the audience? No? Okay, go ahead.
Mary, there's someone at the door.
Ma'am, you'll need to sign in, or you'll get it, okay. Sure, that's okay. Oh, another one, all right, good.
The first case is on section 7.4 of the agenda. Case 7595. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7595. Property owner Park Lake Inc., site address 3184 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was sent by regular mail 9/23/22, handed on 9/6/22.
Is Park Lake here? Well,
Yes.
come on up.
A notice of formal hearing with a copy of the notice violation was sent by certified mail May 26, 23rd, and posted to the property June 9, 23rd. The violation was for installation of an AC unit on the roof without a permit. At this current time, as of May 25th, 23rd, there was an affidavit of noncompliance because there was no permit for the actual AC on the roof. My recommendation is to give them 30 days to comply, if not a per diem of $250.
Okay, if you could announce your appearance, please.
Yes, my name is Bertrand Sese. I'm the general manager of Park Lake Estates.
Okay, what would you like to say, sir?
That actually what happened with this case is that the permit was open, but because the city forced us to put a fence around the AC, we could not close it. In any case, the permit, the AC company, who is in the audience now, is just waiting on one piece of paper, and most likely this week they will get it, then we can proceed.
Okay, and did you need more time than 30 days?
No, I believe 30 days is fine.
Okay.
And for the fence is built. We're going through inspection today.
Okay. All right.
Okay. Nothing else. Okay, based on the testimony of its compliance officer and what's been presented, there's substantial competent evidence to support the city's position. The owner will have 30 days which to comply, or $250. So please comply. If you need more time, please contact the code officer before the end of the 30 days from today, all right, for an extension, and see what happens, all right?
All right.
Okay, thank you. Good luck to you.
Okay, thank you.
Yeah, there were the two people that came in. I'm going to need to put you under oath, and I don't want to forget to do that. Are you going to, the two people that came, are you going to testify today? Are you here on a case? Okay, whoever is going to testify, that I think two people came in, or is it one? Ma'am, when you going to testify? Okay, could you raise your right hand? Okay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you very much. Go ahead. Oh, you need to sign this. Okay. Oh, front and back, all right. Within 30 days. I forgot to do the most important thing here. Okay, go. Yes.
You keep looking
Great.
back at the screen.
Thank you.
Is there too?
Yes, thank you.
Oh. Okay. All right, so the following cases, it belongs to the same property owner. So I will present the first case individually, and then there's a few cases for confirmation of fines. So I'll start with the finding of facts and in the order of the agenda. The first case is 8438, and that is on section 7.10 of the agenda. Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 8438, property owner Infinity Azure LLC, site address 3294 Southwest 52nd Avenue, Pembroke Park, Florida. A notice violation was sent by regular mail, April 27, 23rd. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, May 26, 23rd, posted to the property and town hall, June 9, 23rd. The violations are for item 1, roof is severely damaged, obtain plans for permit and complete all inspections for repair. Item number 2, installation of water heater without a permit, obtain an after the fact permit. Item number 3, installation of AC unit without a permit, obtain plans for an after the fact permit and inspections. This is a repeat offense. There's a final order submitted that it's case 7745. Since this is a repeat offense and the roof is severely damaged, my recommendation is to give them 30 days to obtain these permits, if not a per diem of $500 and admin fee of $100.
Okay, let me see, this is a hearing to confirm fine or?
No, this is the 8438.
Okay, I've got 8438 here. It's a final order, but,
Yeah, are you going by the updated agenda?
no, the one you sent yesterday.
That should be updated.
Okay, all right, it doesn't matter. You're correcting all that, no big deal.
Okay.
Is Infinity Azure LLC here?
Yes.
Yeah, come on up, ma'am. Your name, please, and your position.
My name is Juani Merced, and I'm the senior property manager.
Okay,
Juani,
go ahead.
can you make sure that the button is pushed? Yeah, there you go.
Go ahead.
Oh, Juani Merced from Infinity Azure. I'm the senior property manager.
Okay, what would you like to say?
For this case, we already started beginning the process. We already found the vendor, and he is submitting the permits this week for the
Okay.
roof.
Go ahead. Good. Go ahead. You were going to say something else?
No, for the roof.
Okay, all right. This is a repeat violation. So this has happened within 5 years before, I think the statute says. So I'm going to follow what the city says and go with, I'm going to find that there's substantial competent evidence to support the city's position. You'll have 30 days in which to comply.
Mr. Hebler?
Yes.
I believe there's a few people in the audience that,
Sorry.
that
Okay.
would like to speak on this case.
Okay. Yeah, when I call the case, and I probably didn't say this,
Would you like to speak on the
please
case, sir?
come up to the microphone so
Here's your moment to come and speak on the case. I'm going to translate for him. Que en el momento puedes hablar en referencia al caso del techo. Sí. Sí, ahora puedes venir a decirle al magistrate lo que quieres decir.
¿Lo puedo hacer en español o mi hijo lo puede hacer en inglés? Como usted mismo.
En inglés.
¿En inglés?
Sí. Él te puede traducir.
Vamos, Good morning.
Buenos dias.
Say your name.
Thank you so much.
Whatever.
Say your name for the record. Di tu nombre para grabar.
Ok, mi nombre es Javier Gutiérrez Jiménez
Okay.
y somos residentes de la casa 3294 en Azure Villas.
All right.
Y mi hijo es Juan Pablo Gutiérrez, que va a traducir.
Okay. Do you-
His son is going to translate for him.
okay. All right. Go ahead.
Okay, so we wrote like a relate of our
Please,
experience.
I'm sorry. Please speak into the mic.
Microphone.
Okay, good morning. So we wrote like a script or like a summary of our experience, and so it's like evidence of how in repeat occasions we asked for like support on our case, but like the situation is still the same and it's even worse. So on Tuesday, April 11 at 3:15, we were at home when a tornado hit the roof of our home located at 3294 Southwest 52nd Avenue. This left the house uninhabitable. The incident was immediately reported to the property manager, and we were temporarily relocated to 5420 Southwest 32 Avenue, a one-bedroom property. On Thursday, April 13, they covered the roof of the house with a protective tarp, and we asked that if it was going to be delayed, please relocate us to a two-bedroom house, similar to the one we have for rent and that was affected by the tornado, since we are a family of 4 people, including 2 minors of age. The answer was that there were no such units available. We asked them for the house across the street that was empty and has 2 bedrooms, and they told us that that house had leaks, so we couldn't inhabit it. We informed them that still the one-bedroom house that they assigned us has leaks too, but this didn't matter to them. On Tuesday, April 18th, we observed the works were being carried out on the roof of the house across the street, the same one that we requested to relocate us while ours was being fixed. Given this, we went to the manager's office to ask if the repairs were going to begin in our house, and the answer was that no, that these works were previously scheduled and that ours was not yet known for when. We then asked them again to assign us the house, and they told us no, because it was already going to be rented. On Wednesday, April 19th, we went to the property manager's office to find out how the restoration process was going, and they informed us that it was stopped due to the Jewish holidays and that they had no certain information about when the repairs will begin. On Friday, April 21, we observed that 10 days had passed since the incident and that there was no precise information about when the repair work would begin. So we decided to inform the city of the facts, and they immediately carried out an inspection of the shattered house. On Friday, May 5th, we sent a communication via email to the property manager's office requesting an adjustment of the amount of the rent we were living in a one-bedroom property, a request that we consider fair, taking into account that we haven't lived in the two-bedroom house that we have contracted since April 11th. We never received a response, and on Monday, May 8th, they sent us a collection letter for the rent with the price of the two-bedroom house and additionally an additionally fine of $150 for late payment. Understanding that they had dismissed our request, we proceeded to pay the amounts required by them that same day. After this date, we went repeatedly to the manager's office to find out how the process of renovating the house was progressing. The responses were similar, that they had not approved the budget, that they were awaiting a response from the roofers, that the rains prevented work from advancing, and that they even claimed that because we have informed the city, this process was further delayed, suggesting that we were the guilty for their delays. Today, 71 days after that April 11, the situation is worse. The conditions of the destroyed house have worsened. It is visibly affected by toxic mold. The protective canvas has been overcome by the water that enters the property every time it rains. The roof of the living room is about to collapse, among other points. That is why this morning we came before you all to complain about this situation that we consider unfair, discriminatory, and laden with negligence. We continue living in a one-bedroom house and already paying 2 months of rent of a 2-bedroom property without living in it. We hope, given the notoriety of the facts and the violations and irregularities in which the owners of the property have incurred in the improper handling of this situation, compensation, indemnity in accordance with the law, to be able to terminate the rental contract for just cause without any penalty, and that we are given prudent period of time to start the research process for a decent house to live in. We know that this disaster occurred as a result of something natural beyond the control of the owners of the residence. However, we know from the time that we have been living here that the residences are not properly maintained, which is a duty of the owners. For this reason, most of the roofs are defective, affecting not only our residents but also many more. In this event, our material damages add up to $1,853 and counting. With respect, our family, Gutierrez Zuluaga.
Thank you so much.
Right. Okay, you're the tenants in the property that was damaged with the roof and the tornado and putting in the air conditioning and whatever else without a permit. Is that correct?
Can you repeat that, sir?
Are you the tenants in the property that you were removed from?
Tenants?
Yes, you're the tenants. You
They're the
you
tenants.
renting there.
Oh, yes.
Okay, and they gave you substitute housing that's not accommodating to you.
Right. They gave us a 1-bedroom property.
Yeah.
And we were paying for a 2-room property.
Yeah. Okay, ma'am, come on back up. What's
For
going?
Hippler, if we could have their name and
Yeah.
the
Okay.
record.
We have a packet with pictures and like evidence of what we just said.
Yeah.
Sir, if you can state your name.
They
for the record.
stated it initially
My name?
before the.
But go ahead and
Yeah.
do it again. I thought they did, but what's your name again?
That's me.
My
It's
name
okay.
is
That's all right.
it's Juan Pablo Gutierrez Zuluaga, and I'm Javier's son. I'm here just like a translator. He wrote the script.
Okay. All right. And all right. And you're both living in the substitute housing.
Right.
Okay, with your family.
Yes. My mother, my brother, my dad, and me.
Okay. All right. Okay, ma'am, come on up.
Thank you.
Thank you so much.
Yeah. Don't leave yet. I may have more questions. Just hang around there. Go ahead. Go ahead. Yes, ma'am. What do you have to say?
Well, the day that it occurred, yes, it was an emergency because we didn't expect for that to happen. I did place them in a temporary home. That's the only unit that we have right now that it's ready. And I don't know about the other issues about the rent. He's saying that you guys want to move out.
Ma'am, he's not saying that. I think.
Yeah, he said he wants to.
Oh no, he wants a substitute place like they had.
Right, and
Okay.
that's the only apartment I can give him right
Yeah,
now.
yeah.
And try to accommodate him to a 2 if that's what he wants. But if he also wants to leave, I understand, and we're okay with that.
Yeah. Yeah.
I don't know. We're working as fast as we can because the problem was when the roof collapsed. It was a Jewish holiday, and unfortunately, the owners are Jewish.
Yeah.
They were not in town. I cannot approve something that big.
Right.
So I had to wait for that. After that fact, they went ahead and approved it. But by then we got the violation, and that's I think what he's pertaining. That then I told him it's gonna take longer because now the vendor has to request a permit. That's not something that we can just fix.
Yeah.
So the vendor requires a 50% before he submits permit. So we submitted that, and unfortunately, somehow in our accounting system, it got like stuck, and they didn't get the payment on time. Now, however, they did receive the 50%, and they are submitting the permits now. That's why it took a little late. It's not because we didn't want to do it. It was just the fact. Plus, the vendor now, with all this rain and all this work, it's very hard to
Yeah.
for him to be able to
Okay.
to fix it right away.
All right, Ms. Ramirez, this is a repeat offense. So when was the prior offense by this owner? If you happen to know, you know.
All right. I included it here. 1 second.
That's all right.
So the final order was for case 7745, and that was ordered on November 16, 22.
22? Okay. All right. Okay, anything else from anyone?
So with the repeat offender, with the repeat violation, sorry, it's because the roofs are bad. We acknowledge that. We are fixing them as we go. But that roof was not really, I mean, in our control. It was the weather. So that's the only thing that, if it was a leak, we reported before, we would address it.
Okay, anything else from anyone? No? Okay, thank you all. Without the testimony that I heard, I made a ruling. I'm going to revoke that, okay? This is a repeat violation according to 162 point whatever. The city actually can go back to the date of the violation. They're seeking to give you 30 days and $500 per day. Your son will explain it to you, or Miss Ramirez will, sir, okay? So they're not doing that. However, and also just as a caveat to all this, I cannot get involved in substitute housing issues. I mean, I candidly, from a non-magistrate position, I think the right thing to have done would have been not to have sent a demand letter that they were paying less, which quite frankly, under landlord-tenant laws, I recall they could do, but I don't do that anymore. But that's something you're not aware of, but that's what they're saying, to give them substitute housing. I can't make you do that. I don't have jurisdiction. What I do have jurisdiction to do, though, because it's a repeat violation, is I'm not going to give you 30 days. I'm giving you 10 days to comply with all the violations, or $500 a day, and you can do whatever you want, okay? That's basically it. I'm going to find that there's substantial competent evidence to support the city's position. I'm going to find it's a repeat violation. Under the statute, the city can go back retroactively, which means that there would have already accrued, from March or April, $500 a day. The statute says that. But they've been trying to work with you, and I don't know how that's working out, but here it is, as I recall, July 11th or whatever date it is, 21st, and that should have been occurring immediately, whether or not a Jewish holiday or not. I'm Jewish, okay? Passover, I assume they're referring to Passover, which is really not a high holiday, most respectfully. Rosh Hashanah and Yom Kippur is September and October. So I don't buy that, okay? But, some people of Orthodox connection, beliefs, take a day or two off and the like. But that's fine. But it is a repeat violation. So you go back and tell the owner 10 days to comply. The $500 per day will begin to accrue after the 10 days, and they can act accordingly because it should have really been done. And yeah.
I say something. Because it is a roof, I find it a little hard to do it in 10 days.
Ma'am, I make the ruling. You're going to have to act accordingly. It's a repeat violation. It isn't just the roof. There's an AC unit here, I believe, and correct me if I'm wrong, Miss Ramirez. AC unit
And water heater.
and a water heater. I mean, look, I know people, nobody wants to pay permit fees. They want to see what they can do without it. Those are two basic things, a water heater and air conditioning. You apply for a permit, but that's something you'll have to consider. Again, I have no jurisdiction to order you to give them substitute equal housing. That's not my prerogative and the like, and that's between you and the tenants. But under the circumstances, I think the right thing to be done to do that, but I'm not you. It has nothing to do with it, but I do have jurisdiction to go with a repeat violation. So, that's my ruling. 10 days, $500 a day beginning after the 10 days, and so be it. All right?
Got it.
Okay, good luck to you, ma'am, and, the owner as well, okay? If you want to explain that to the gentleman here, the tenant and his son, your son did a great job interpreting what goes on, yes, good.
No, someone's at the door. They keep it locked. So,
Oh,
yeah.
okay. Okay, so within 10 days.
Mr. Hippler, may I just add one thing to the record?
Yeah.
Just let it be noted that the Florida Building Code does provide for permit exceptions
Yeah.
and after the fact applications for emergency repairs.
Right. Okay. All right. Well, have they done that?
No, I'm just saying as far as they're saying 10 days is not enough, I'm
Yeah.
saying it's reasonable because
Yeah.
the Florida Building Code allows for that.
Okay. Well, he's the interim city attorney. He knows the law better than all of us. And I won't make a determination, but quite frankly, I'm not sure if I would be inclined to grant an extension of time either, because if it's me, that it comes before for that. So you got my ruling. Take care. Good luck to everyone.
Thanks.
Okay?
I got it.
Okay, there are a few more cases for confirmation of fine.
Okay.
So I'm just going to present each one of them.
The order will be given to you. They're going to make a copy. Okay.
And then, did you want us to pause every time per case, or do you want me to present them all at once?
You can do them all. It's just enough time for me to fill the order out right, so I don't make an error on the order and the like. So go ahead, please.
All right, so just so you can get the orders, that would be case 7745, 7750, 7958, 8076, and 8079.
Okay.
And they're all for confirmation of fine.
All right. What do you have? Oh, did you say something or no? You were just. No.
No. I don't know if you're ready to rule. If not, I would add more to the record.
Go ahead. No, please. Good.
So, Ms. Ramirez, and all those cases are not in compliance?
No.
Okay, and would the respondent like to address any of those cases before Mr. Hippler makes a ruling as to a confirmation of fine for the fines that have accrued in those cases as read, as far as the testimony of Ms. Ramirez and the record for the file on all the cases?
As far as the permits, they are being requested. It's a AC permit.
Ms. Wani, can you just make sure the mic is on, and if you could speak into the mic?
So as far as the AC permits, they are being requested. We're facing some issues with the mechanical part, but we are working on that. And then the water heater as well. We are working. They are already installed, so it's just getting the permits and complying with that.
So, but on any of the other cases that were read, because it's case 7745, 7750, 8076, 8079, 7958. Mr. Hippler is considering all those simultaneously, so I wanted to see if you had any additional testimony or evidence that you'd like to present on any of those cases.
No, not at this moment.
Okay. Just wanted to make sure.
Correct.
Okay. Anything, Mr.
I'm just going to present them one by one for the record.
Okay, great. Okay.
I just like to add that there is partial compliance on the cases. So they have been working. They haven't left it, just sitting there.
Okay. All right. Well, that's great. Okay, go ahead.
All right. So we'll start with case 7745. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 7745. Property owner Infinity Azure LLC. Site address 3302 Southwest 54th Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail May 26, 23rd, posted to the property in Town Hall June 9, 23rd. And it is the town's motion to confirm the fine of $39,350.
Anything to say, ma'am?
Yes, I would like to see if I can get that reduced.
It's too early for that. You have to have compliance before you can come back for a mitigation or an abatement. And there isn't compliance thus
Okay.
far. And I think some of I'm not sure if Pembroke Park does it, you're going to need to have complied with all violations of Infinity Azure LLC before you can come back for any of them, I think. So that I'll defer to the city on that or to the town on that. There needs to be compliance before that happens. Right, there you go. So I'm going to go ahead and approve that and the lien as well for $39,350. It'll continue to accrue $100 per day until there's compliance. And that's in 7745. Great. Okay, thank you.
One second. Okay. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7750, property owner Infinity Azure LLC, site address 5410 Southwest 32nd Street, 5420 Southwest 32nd Street, 5412 Southwest 32nd Street, and 5414 Southwest 32nd Street. A notice of hearing to confirm fine was sent by certified mail May 26th, 23rd, posted to the property June 9, 23rd. And the amount to confirm is $39,350.
Okay, anything, ma'am?
If I can
Any
get,
additional?
if I can request more time before the fines.
No, we're not here for that. Okay, so I'm going to confirm the fine. So it'll continue to accrue at $100 per day. See, candidly, I mean, when I heard the first case, I wasn't even aware of the others. I mean, this is like an ongoing saga of non-compliance, really. So what can I say? So I'm going to go ahead and confirm the lien in 7750. Next case. Thank you.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7958, property owner Infinity Azure LLC, site address 3351 Southwest 55th Avenue, Pembroke Park, Florida. It is the town's motion to confirm a fine of $72,600.
Okay. Anything, ma'am? You want to say it, now is the time.
It's the same thing. We're just waiting on the permits.
Okay. I'm going to go ahead and approve that. The fine as of today is $72,600. It'll continue to accrue to, this one's a per diem fine of $500 per day. The other one, I may have said $100 a day. I may have been wrong or not. Whatever it says in the order is what counts. So I'm going to go ahead and confirm the fine for that amount in 7958.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8076, property owner Infinity Azure LLC, site address 5425 Southwest 32nd Street, Pembroke. A notice of hearing to confirm fine was sent by certified mail May 26th, 23rd, posted to the property and Town Hall June 9, 23rd. It is the town's motion to confirm a fine of $55,600.
Any comments? No. Okay, it's up to you. I'm going to go ahead and confirm the fine. It'll continue to run at $500 per day. $55,600. This is in the case number 8076.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8079, property owner Infinity Azure LLC, site address 5210 Southwest 32nd Street, Pembroke Park, Florida. Notice of hearing to confirm fine was sent by certified mail, May 26, 23rd, posted to the property in Town Hall, June 9, 23rd. It is the town's motion to confirm the fine of $55,600.
Any comments, ma'am?
No, sir.
Okay. I'm going to go ahead and confirm the fine, $55,600 to $500 per day. Okay. You have the rulings. You'll get copies of the order. You know what you need to do. Good luck, okay? Take care. Bye. May want to take a little break here to give staff to complete that, just a minute or two, so.
Next case is on section 7.3 of the agenda, case 7587.
Yeah.
Pregúntale a Nasli.
Yeah, this is Jose Colmenaras.
Yes,
Okay, if I butchered your name, your last name, forgive me, so.
absolutely.
Yeah, we're gonna let the city go first. I just wanted to make sure you're up here. Great. Thank you.
Okay.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7587. Property owner Jose Colmenaras. Site address 2307 Southwest 31st Court, Pembroke Park, Florida. A notice violation was handed on September 6, 22, sent by regular mail, September 23rd, 22. A notice of violation with a copy, a notice of formal hearing with a copy of the notice of violation was sent by certified mail, May 26, 23rd, posted to the property and town hall on June 9, 23rd. The violations were for bathroom renovation done without a permit, obtained plans for permit inspection. That has not been corrected. One moment. Screen room. There are items here. Item 2 for an addition. That violation has been removed. Item number 3 for a screen room has been removed. AC unit without a permit. The item number 4, which is AC unit installed without a permit, has not been in compliance. There's still not a permit for it. Item number 5 is for a shed without a permit. That has been removed from the violation. Item number 6, installation of a wooden deck without a permit. That has been removed from the violation. Item number 7, exterior maintenance require pressure wash and paint mobile home. That has not been done. Item number 8, outdoor storage, remove outdoor storage. I did not see outdoor storage upon my reinspection, so that has been done. And exterior maintenance of overgrown trees, to trim trees, that has not been done. So that needs to be corrected. My recommendation is to give them 60 days to comply, if not a per diem of $100 per day
Okay.
and a $100 admin fee.
Okay. Okay, come on up. You know, if can the gentleman stand? Does he have difficulty standing?
I'm okay.
You're okay. All right, go ahead. I
Yeah.
just
Very gentle.
okay. Your name, both your names, please.
Yeah, can you please push the button to make sure the green light is on?
The green light is on.
Oh, okay, perfect.
Di tu nombre.
Mi nombre es Cielo Ortiz.
Okay.
First, good morning. My respect to all the panel. I'm here to serve as an interpreter for her. She's my cousin wife. My cousin is absent due to training. He's in out of town. He's doing his training, recurrent training as a pilot. And I'm trying to help as much as I can.
Okay.
I'm not very familiar with courtrooms, believe it or not, but this is the first time in my life I've been in a courtroom.
Well, you should welcome that. Hopefully, it'll be your last time. Okay.
Well, I hope it'll be the last.
Okay. Well, if it isn't, nobody will hold that against you too much. You know.
Okay.
I mean, we do have someone that we're all aware of in the news recently. It just keeps popping back into court, but I don't think you're relation to him. So, go ahead.
Nice to hear that.
Yeah.
Okay. El señor José Colmenares murió el 15 de abril. Claudio Colmenares, que es mi esposo, es el que va a asumir o el que está tratando de asumir todo.
Ok, le voy a decir que está
Lo que
tratando.
necesitamos es tiempo y una reinspección para ponernos al día porque todo esto es nuevo para nosotros.
Okay, Cielo is telling me that the owner, Jose Colmenares, he passed away last April 15. And his brother, which is my cousin, he is inquiring about this property to see if it can handle and comply with all the requirements from the city.
Okay.
And they're only requesting as much time you can give them, if it's possible.
Okay. Good. There's been some compliance with some of the violations, right? A few of them.
Just one, it's the outdoor storage, and then a few has been removed.
Okay. But the big ones are there's been no compliance.
Right, which is the bathroom renovation. There has been no compliance.
Okay.
But my condolences to your family.
Yeah.
If they do need more time, 90 days.
All right.
90 days?
90 days to comply, to get the permitting in, to get it complied with. You should be able to do that. So if you need more time, as long as you're showing that you're trying to comply and you're doing the best you can, but if you want more time, you need to file that request before the 90 days is up, or somebody needs to file it with an email or handwritten anything. Okay.
Perfect.
All right.
Entendiste? Are you happy with that? Could I just do a simple personal question? It's my personal question.
Sure.
Just in case. There's just an case if you decide not to take this property. Is there any penalty or any procedure to follow?
I don't understand.
Okay, like I told you before, he had all the best intention to improve the property and keep it. But if for some reason, and this is my personal question, he decided not to proceed, is there any fee or anything or any penalties that will aggravate my cousin directly?
Well, I mean, how do you demolish with a bathroom? I mean, if it's been done, if you demolish it, you're still going to have to complete it. I mean, you know, it's not like demolition of an outside shed or something like that. What you
I think what you mean is, so if your cousin chooses to do nothing, yes, the
Exactly.
penalty will exist, because after the 90 days, you'll start accruing $100 per diem per day, you know, until the violation is corrected.
Okay.
So is that what kind of the answer you're looking for?
Well, yeah.
And then so-
Because my confusion is, there is nothing that says that that is his property, my cousin's property. It's just he's looking at the possibility to improve and make it illegal, and I can give a good faith of his intentions.
Yeah. So
This is very-
whoever acquires this property will acquire the violation. It doesn't matter who
Oh,
it is.
okay, all right.
Lo del baño.
Okay, she wants
La
to,
inspección porque no hay ningún tipo de remodelación en el baño.
there was not inspection in the bathroom because she haven't seen any kind of remodeling. Huh?
Está viejo.
Yeah, it's really old.
Mary, can you please show the photos of the bathroom renovations that were being done at the time? So are you saying that right now they left it without a bathroom?
Lo dejaron sin el baño, ahorita, en este momento.
No, el baño está totalmente podrido. Todo.
Yeah, she says
So
that
you're saying the bath,
completely destroyed. I mean, so her question is,
Una
do they need a reinspection or just
no, so since he did this without a permit,
okay?
you have to obtain a permit.
Okay,
Whether it's you're gonna cap everything and make it a room, you gotta submit plans to the building department. What plans do you have for that room? To
oh,
fit?
absolutely, I understand.
So
Yeah,
are you
I'll
gonna
explain
cap
it to you.
everything, or are you gonna redo a bathroom? You need
Exactly.
permits for.
Yeah, I will. Yeah. Okay. Other than that,
does anyone actually use that bathroom?
no.
Okay, well, I
No,
hope-
since they got in charge. I mean, they're trying to make it, clean it, and do a lot of things, but
you know, to walk on, I mean, you're like walking on a plank. You could fall in.
yeah,
No, okay. I mean, it's really dangerous.
it is. It is. I'm agree with you, and
You know,
their intentions, like I said before, is improve.
I know, but if somebody wants to live there, just get it done. It's going to cost some money, and you know that's life. Okay.
Yeah, it is. I'm agree with you.
Yeah, okay. All right.
That's why we're here for.
Yeah, I
Spend
know.
our,
I know it's 90 days. It's make progress, get it done, and the city will work with you. This officer will. She always does. Okay, but get it done. Don't wait to the 89th day to do something.
oh, absolutely. Yeah.
Okay. All right. I'm going to find there's substantial competent evidence to support the city's position. 90 days. After that, $100 a day. So you don't have plenty of time, but you have more time than is usually customarily given to get this done.
Do you think they're in the process to transfer this property under his name, my cousin's name?
I don't know. That's a legal question. We don't, we're going to really, if it has to do with code enforcement, that's fine. I don't mind trying to answer it. Hopefully I'm not wrong and the city isn't, but I don't know that about transferring it. I don't know who would want to buy that in that condition, but
Okay.
a lot of, Brooklyn Bridge maybe, I don't know. But
So the reason of the question is because she's concerned about if it's enough time, 90 days.
ma'am, sir, you need to start getting it going. if you need more time, as long as you make progress, the code officer may be inclined to extend the time.
Absolutely.
If you do nothing, it's not going to get extended.
Yeah.
Right?
Okay.
Okay?
I understand.
All right. Good luck, both of you.
Thank you very much. And if I ever get in trouble, I wish to have somebody like you too.
I don't know, whatever.
Well, thank you. The good thing is the only trouble that I have is with my wife, and we don't go by the law.
Yeah, okay, well,
Thank you very much. And
it's spousal privilege. It's the way it is.
I understand.
The M word, married, okay? It's okay.
All right.
Welcome to the club. There you go, whatever.
Beautiful day, all of you.
Go ahead. Yeah.
All right, the next case is case 7888. That's on section 8.4 of the agenda. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7888. Property owner Pembroke Park Warehouse Holdings, site address 3121 Southwest 21st Street, Pembroke Park, Florida, Bay 675. A notice of hearing to confirm fine was sent by certified mail May 26, 23rd, posted to the property and town hall. June 9, 23rd. The property is still not in compliance. And it is the town's motion to confirm the fine of $75,600.
Is Pembroke Park Warehouses holding here? Oh, come on up. Yeah,
Hi, my name is Levi Horvath.
yes.
I'm on behalf of Pembroke Park because Nancy Romero, who's supposed to be here, who's the manager, has dead in the family, so I
Okay.
came to help.
Well, okay.
So I'm here. We applied already a year ago, meaning we hired an architect a year ago. They working on the drawings. We still don't have the drawings. So I don't know what to say. There's nothing I can say. This is already the third architect we hired to do it because the other ones didn't we waiting so long.
Yeah.
So. And the same thing, I tried to build a house for my son and the same thing, I have an architect for a year and I still don't have drawings. So, and that's in Hallandale. So
Yeah. Okay.
I don't know what to say.
No, nothing. Just keep plugging at it. I don't, it's too bad that professionals, if they're not getting paid, they're not going to do the work. I don't know.
Well, I pay them. I can prove we pay.
I know.
everything.
I'm just saying. I have no clue. Okay, if they do.
And I
or-
need, because I rent a place there, and basically it's because of me, I need to build my office and I need to run my business there. So
Yeah.
even with the occupation license, I pay because I had a different unit. I pay renewal and everything,
Yeah.
but I cannot get it because on this unit it's a violation. So we have to fix it.
Yeah. Well, as of now, the town get compliance whenever you can come back for mitigation, and the town has a good mitigation process. Some people think it goes too low. Some people say there shouldn't be one. Some people say it's too high. That's just right now. They'll reduce as long as you comply. But that's enough for another day. So you just need to keep plugging along and get compliance.
Yeah, definitely, no problem.
Okay.
We're working on it. That's no.
Okay, very good.
Question.
All right, I'm going to go ahead and confirm the fine and a lien in the amount of $75,600. Okay?
Thank you very
All right,
much.
thank you. Good luck.
Wonderful day. Thank you.
Yeah, Nestle will give you a copy. Next case is on section 9.2 of the agenda. Case 7182. Yeah, I believe there's two, but yeah, you may wait. Okay, Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 7182, property owner 400 West Honda Beach Boulevard, Unit 4, Pembroke Park, Florida. A notice of hearing to abate fine was requested via email on June 16, 23rd. It is the town's motion to abate the fine of $59,600 and reduce it by 80%. So the total amount is $12,000, and that includes the admin fee.
Okay, go ahead. What would you like to say?
Good morning. My name is Kadir Puentes. I'm the real estate agent of the owner, VNA Miami LLC. It states on the record that it's a repeated violation. They hire a property management since they purchased the shopping center. The property management was negligent, and he actually, while he was hired to manage the place, he went to live to another country. So that's how bad it was. The shopping center, Joseline could confirm, had plenty of issues of all kind. We're talking hundreds of thousands of dollars in issues. I took over in November 2022. Out of 9 issues, this is the last one. So the property, it's clear. I know that, just because you have a bad property management doesn't mean the owner doesn't have to do their job. But when you pay good money for management, that's what you expect pretty much.
Of course.
Well, I took over. It was presented everything to them, all 9 issues. All 9 are, except this one, paid and fixed. A lot of money was put in. This one in particular is the one of the restaurant, which they purchased the restaurant from somebody else. And, they also didn't know that the previous owner of the restaurant, not the shopping center, did something without permits, some other stuff. So they also didn't know that. Once they would put in notice, they started working on it. The restaurant spent $4,800 plus $1,000, almost $6,000 in the exhaust cleaning and piping and the electric panels and all of that. So it will be, both the shopping center did their part once they were aware of what was happening, and the restaurant as well. It would be greatly appreciated if we could lower a little bit more.
What's the number that you want me to lower it to? I mean, I'm not going to necessarily grant that, but what's the number?
$3,000.
How much?
$3,000.
3,000? No.
No.
Okay. No. Is this, you said you're an agent, is this place for sale?
Yes.
Okay, all right.
The reason what is for sale is because he had such a bad experience.
Right, no, I understand.
That he wants to move on and not have these issues. So
yeah,
as I mentioned, I did my best to resolve everything. Everything was paid. Everything was diligent and in timely matter. I believe everyone, Jeffrey, Nasli, everyone knows me because I come here probably 2-3 times a week bothering them just to make sure, things get done.
Mr. Hippler, if I may add.
Sure.
What he's saying is true. They've had multiple violations, but they have corrected. Many tenants and the property owner have accumulated fines of $6,000, $8,000, and they have paid those fines as well.
Okay.
I believe this year they have paid about how much altogether?
Around probably 20,000, 25,000
in fines
or less. Plus those are only fines, plus tenants repairing. Tenant number 5 spend probably $10,000. Tenant number 6 spend $3,500 plus the $3,000 in fines. Tenant number 1, because of a banner, they paid $36,000 plus the removal just of a sign. It was 3 signs. Just the removal of the sign, it was $3,000. But the tenant vacated the premises, so the landlord got stuck with this expense. And the previous manager only required 1 month deposit of $1,500. So, I mean, it's funny, but not really, because it's a lot of money.
No, it isn't funny, but it is funny as long as you're not the one that.
Paying that, right? And I'm not paying that, but it is my client, and I'm thinking of writing a check for $3,000 for signs that are not yours, and it hurts.
Of course it does. Okay, what I'll do, I'm not going to go to 3,000. This is my custom. The city has reduced it by 80%. It was a repeat violation. I have to consider that as well. I don't know. I'm torn whether not reducing it at all, but it's my nature to want to do that so that these things get done and the town moves on. Yes, and that the owner moves on. Yes, good.
It is a repeat violation because many tenants had the same type of issue.
Yeah.
But once the owner knew about everything got fixed.
Okay.
And after we knew about it on November 2022, there were no more issues, and she can attest.
Okay. Well,
so
is that legit or not? You can't say, or what?
There was one more violation, but he worked really hard to start closing.
The parking one, but
It still hasn't reached magistrate, but other than that, he's fixed it. He's fixed multiple things. There's only one item, and the case is about to be closed.
the contractor called me and he told me I need to pay the permit, and it's done. So I'm gonna pay it right now.
Yeah. What would be 15%? Could you calculate that for me?
15%.
Of the 59.5,
10 is a better number.
because this is 20%, unless I am misreading this. So
9. It would be 9,025.
okay, I'm gonna reduce it to 9,500. Okay, that's the best I can do. All right.
Okay, thank you very much.
Ms. Ramirez, you need to thank the town, because towns don't have to do this, rightly or wrongly. They don't have to, in reducing the fines and the liens. So I'm going to go with 9,500. That'll include everything. Is that acceptable? Okay. Okay, I'm going to go with, and how long do you need to pay?
Oh no, we're gonna pay between today and tomorrow.
Okay.
We're gonna pay right away.
Well, I should have left it then at the other one. So okay. I'll like giving breaks if I can. Okay. So 9,500. Is 10 days enough time?
Yeah.
Okay, within 10 days.
And yes, you are right. You have a fantastic team. They all help me. I've been bothering Maria and Jeffrey nonstop. Nasli, Jocelyn, tons of emails.
Yeah, we're tired.
And Mr. Hippler, if I may just add to the record that after the 10 days to pay, if the fine is not paid, then it automatically reverts back to the full amount.
Yeah, thank you.
So make sure you pay it, and she works 28 hours a day, I'm sure.
Yeah, I know.
Or is it 32 hours a day?
32.
So. Okay, 9,500 within 10 days, or it reverts back to 59,600. And again, is the most knowledgeable city attorney says, if you don't pay it, it goes back to the original amount. All right?
Perfect.
Okay, good luck to you.
Thank you very much. Thank you.
Thank you.
Next case is 5387.
Great, thank you.
That's on section 9.1 of the agenda. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5387, property owner, Pembroke Park Warehouse Holding, tenant Air Concepts AC Service Inc., site address 3170 Pembroke Road, Pembroke Park, Florida. Sent by certified mail, May 30, 23. Posted to the property and town hall, June 9, 23. It is the town's motion to abate the fine of $63,950 and reduce it by 85%. The total is $9,763, and that includes 2 admin fees.
Okay, your name for the record, please.
Good morning. John Southard. I'm the Chief Operations Officer for Air Concepts, and this is Claudia Pinzone, the Chief Executive Officer.
Okay. All right. What would you like to say?
Well, Your Honor, if I may call you that.
I'm not a judge, but, you know...
Your magistrate.
That's better, but flattery may get you somewhere. I said may or may not, so... whatever.
Well, if I may address this astute establishment.
Sure.
We were the tenants, and we've been here before, and we complied within the time limits that was given by the city. The original violation for a build-out structure, I guess you would call it, we were given 90 days to comply by pulling a permit, which we did. We submitted plans. We hired an engineer. We paid the engineer $4,000 to provide drawings. He provided the drawings. We submitted them to the city. We paid the application fee, or the expediting fee. So we were in compliance almost immediately. Within the city denied the permit due to some changes that needed to be made to the plans, which we couldn't get done because the engineer committed suicide during COVID. So we weren't able to get him to do the changes. We attempted to hire a new, but the owner, Pembroke Park, decided that they didn't want the build out anymore. They just wanted to do the demo, and they wouldn't agree to sign the permit, which we couldn't pull the permit. We're not the owners. So we, it was taken out of our hands by the owners, and they hired an engineer, and they submitted the plans for the demolition. We paid for the permit fee. We paid $2,604.24 already, which is the double permit fee for the demolition. We paid for the demolition. We got the permit closed within 2 weeks after receiving it. Like I said, we've paid over $20,000 for this whole process already. We appreciate the city's, generous abatement, but it's still a lot. $9,000 for a small business is a lot of money. We've been very compliant. We've done everything asked of us that was within our power. We're not the owners, but we're told to demo. We said, okay, we'll demo. No, you can't demo. You need to pull a permit. Okay, give us a permit. No, you need plans. We have to hire an engineer. So there's a lot of delays that were beyond our control. I don't feel that the number of days is correct, because we were given extensions.
Okay, why is it not correct?
Because we were given extensions. We were given time.
Are you sure?
Yes, sir.
Okay, were there any
There was an extension of 60 days.
Okay. Even after the extension lapsed, it continued to it began to accrue.
Right, because we close out, we enter an affidavit of compliance at the time that all the final inspections are completed.
Okay. And you're the tenant, you're not the owner. You're here, the owner is ultimately liable, but they'll come after you if you don't pay, obviously, or you don't comply, so.
Right, and we're being responsible for, what was done. We were misled and told that we didn't need a permit for the build out, and we paid a GC to do, the person that did the build out didn't pull a permit and they ran away. But we're trying to do the right thing.
Okay, the architect that unfortunately committed suicide, and how long did it take you to get another architect after that?
We weren't able to get another architect due to COVID. And then the city, the owner said that they didn't want the build out. So there's no reason to pursue another architect because we couldn't do the work or pull the permit.
Mr. Hippler, if I may.
Go ahead, sure, please.
Thank you. I just want to also state for the record, I know that the gentleman in the back in the red said he was here earlier for Pembroke Park Warehouse Holdings. So I think this is one of the additional cases that's on. So at least the representative of the owner is here on this case.
Yeah, is that right, sir? Yeah. Well, come on up as well, so. They're making the case for a reduction, obviously, so. You say you're a small business owner. How many employees do you have?
We have 6 employees.
Okay, and tell me specifically what you do.
Yeah, we're an air conditioning contractor.
Okay,
We have 6 employees
all right, and how long have you been in business?
since 2008.
Okay, is this, someone may have mentioned that this is a repeat violation? Other than the first one, has there been any other violations by this air conditioning company? Although they're not the
By the
owner.
tenant, no.
No,
This is the tenant's first violation.
Yeah, okay. Okay, I'm gonna, the city's reduced it by 85%. I'm considering everything. What would the amount be if I went with 10%? 10% of what, 63,950 or something like that.
It would be 6,557.
Okay, and okay, then, and the city, the town is going with 95 or 9763. So 9763 for, you said about 6,100. Yeah, okay, there are 2 administrative fees. So I'm gonna go with $7,200. Okay, that's the best I can do. So it's a rather substantial reduction. It's actually closer to 10. There is no going rate, but a lot of the cities go with 10 to 15 to 20%. Not a lot. Some do. Some don't do anything. So I'm going to go with $7,200, and that's a substantial reduction, so.
Yes, sir, I understand, but the original amount is not correct, is what I'm saying. The $63,950 is for more days than we were not in compliance. I don't understand how they're coming up with that number when we were in compliance immediately. We submitted for the permit, meaning we were in compliance.
No, if you submit for a permit, that's really only half the ball game. You submit and get it issued, and it needs to be closed out. It's when you close out that there's compliance.
Okay, I understand that, but when
You want to add
Let me finish first.
Sure.
But when we submit, the city takes 2-3 months to deny the permit. So then you're billing us for the city's not allowing us to proceed or to be in compliance. So that doesn't seem fair that you're holding us up
Yeah.
from being to comply, but yet you're billing us for the days that you're holding us up.
Okay, well, that is a way, I mean, it's a argument, and I've heard it made many times, but there's already, to begin with, the city reduces this by 85%.
Yeah, but you're reducing a false number. You're reducing an inflated false number.
Well, I don't know if it's inflated or not. I don't think it is, but well, let's assume for the sake of argument in this factual determination that you are in, this is what, $500 per day? Or
$250 per day.
$250 per day. Let's say you were in violation for 2 months. That would be 60 days. That's gonna, without any reduction, that's gonna really put you at the same figure.
Yes, sir.
Around the same figure. I mean,
But our argument is that we complied immediately.
but you didn't comply immediately, all right? When you apply for a permit, again, that's only part of the process. You have to get the city to agree that the work has been done, and then they file a notice of compliance.
Mr. Hippler, if I may?
Yeah.
In the backup materials regarding the building permit status, it looks like it was actually submitted for plan review on January 6, 2022. The zoning approval was actually done 1 day later. The structural and fire were denied either the 6th and the 7th within the 24 hours, as well as the electrical was denied on 1/12. The delay that the respondent, speaking of, you're correct as far as your analysis of what compliance is, but as far as any delay of a number of months, that the city, the town initiated and completed its permit review within 6 days.
Okay. Well, how can that be, sir?
May I say something?
Sure, go ahead.
Please don't forget they are the tenants there, and it's so hard to get those people to sign permits, to be able to get, because it's not Nancy's fault, but the owner's fault. So it's not really their fault, it's over there because it's so hard. You apply to Nancy, and you probably know, you apply, you give her the paperwork, and the owner has to sign. So, and then she needs to get back to you, but usually Nancy is not really there all the time, so that's the problem. That's the biggest problem. So it's really not their fault the most. So
I'm sorry, can you please say your name for the record for this particular case?
Levi Horvath.
Yeah. I'm gonna stay with the $7,200. That's really a substantial reduction, and I'm going actually with close to 10%. It might be 12% as I go around with these numbers, and I'm gonna stand by that, because from what the city has stated and the city attorney in educating me, I look at these cases the night before. I do not have a photographic memory. After a while, they start to merge with each other and whatever. That's why I appreciate people educating me. So, and I like to air out these cases so that people know where I stand, and, they may or may not feel better after the fact. I have no control over that, okay? But at least I'm being candid about all that. So this is a really substantial reduction, and so I'm going to go with the 70. I'm going to stand by the 7,200, and that's actually more than it's more than 85%. It's really closer to 90.
Magistrate, $7,200 is more than our weekly payroll. So the city is being very burdensome on a small business for $7,200 when we've already paid over $20,000. We paid the double permit fee You know, we're paying for all of that, and I'm sure there's going to be more expenses when the owners come back to us for payment on the drawings and stuff that they had to do. So you're saying $7,200 is a very substantial thing. It is, considering, you know, 63,000, but you're practically putting us out of business. You're charging me a whole week's of payroll as a fine. If you want to punish us, we haven't been punished enough. For $20,000 isn't enough punishment. The city needs to punish us even more.
I did not put you in this position, okay? Nobody here put you in this position. You put yourself in this position, okay? The owner didn't do it either. You're the tenant. Remarkably, you're here because you're playing by the rules and you want to stay where you are, and thank God you seem to have an ongoing business, okay? All right. You've talked me into a little bit more of a reduction, and this is it. You can take it or leave it. I'm going to go with 6,200. Take it or leave it. Okay.
Thank you, Magistrate.
Okay, 60 pay, but when can you pay?
As we need as much time as we can.
How much is as much time?
90 days.
Okay, 90 days it'll be. All right.
Thank you.
Sure. 6,200.
And again, Mr. Hippler, for the record of the respondent, if that amount is not paid within the 90 days, it reverts back to the full amount.
Yeah. If they left, oh no, you're here. No, you'll need, let me fill out the order and sign it. There you go. Thank you. Thank you.
The next case is on section 7.5 of the agenda, case 7603. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park. Case 7603. Property owner Avihai Saban. Site address 5511 Southwest 34th Street, Pembroke Park, Florida. A notice violation was handed on September 27, 22. It was sent out regular mail October 3rd, 22. A notice of formal hearing with a copy of the notice violation was sent by certified mail May 26, 23rd, posted to the property and town hall June 9, 23rd. The violation was for started interior renovation work without a permit, obtained plans for permit inspections. The property owner has been working diligently in completing the permit. It is my recommendation to give him 60 days to finalize everything. If not, a $250 per diem and a $100 admin fee.
Yes, sir. Your name?
My name is Avihai Saban.
Okay. Are you here for the owner?
I'm the owner.
Okay. It's not an easily pronounceable name, so.
Very easy. It's Avihai Saban.
Avi Saban. Okay.
They can call me Avi.
Avi. Okay. Avi. All right. Go ahead.
I don't have anything to say. Everything is okay.
Is it okay?
I do all my work very slow just because I want to see Jocelyn and Marie as much as I can. And that's why.
You want to tell us the reasons why?
Because they're so beautiful, they're so nice.
I know, we know
I
that.
was never happy to get a violation from this beautiful lady.
You want to give them 120 days? Or, no, 60 days. Okay.
I will need between 60 to 90 to 90 days. I'm sure I will finish it in 60 days.
Okay, if you don't finish it, ask for a request.
Of course,
You'll have to come here again and see them both.
Of course. See, so I'm not finishing it right now. I'm telling you.
Okay.
No, I'm kidding.
You're gonna get 250 per day.
No, everything is good. I'm 85% about to finish, and hopefully by next time when I'll see you, it will be done, and everything will be okay.
Okay, and if you want to come to any of these hearings, you're
I'm coming every day, almost. Ask Marie.
Yeah.
Where is Marie? I'm coming almost every day. I see her almost every few days.
Yeah.
But everything is good, really. Thank you very much. I'm happy to work in this city, to do construction here, and I'm happy to have this city helping me. So thank you very much.
Yeah, you're originally from Israel?
Originally from Israel.
Okay, be careful of those Israeli men.
Of course, I told her.
Beautiful country, been there a number of times, obviously. So,
Yes, it's been.
not recently. I'm too dangerous in my mind.
Lately, it is too dangerous. Yes, but it's always nice to visit.
Yeah.
Just the media always making it more dangerous. It's a safe place.
Exactly. 95 is more dangerous. I know. Great food there, no question about it.
In 95?
Oh, no.
No. I know. Thank you very much, everybody.
I'm going to find there's substantial competent evidence to support the city's position. You'll have 60 days in which to comply, 250 per day thereafter. Thank you for your courtesy. Good luck to you. Thank you. Sure. Within 60 days. Sure.
Bye. Next case is 8109 and 8593.
Pembroke Gardens, are you here? Oh.
All right. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8109. Property owner Pembroke Gardens LTD, site address 3841 Southwest 52nd Avenue, Pembroke Park, Florida. Notice of violation was sent by regular mail, January 27, 23rd. Notice of formal hearing with a copy of the notice of violation was sent by certified mail, June 8, 23rd, posted to the property and town hall, June 9, 23rd. This is a repeat violation. The relating case is 6731, and the final order has been entered into the record. The violations are for damaged chain link fence near back end of the property adjacent to Pembroke Park Place housing, repaired damaged chain link fence. Item number 2, overgrown vegetation, trim hedges and tree near fence area all around the perimeter of the property. Item number 3, underground PVC pipe exposed and damaged near fence area. At this, as of June 8, 2023, they have removed the broken PVC pipe. There's still some work that needs to be done as to trimming hedges and trees, and the damaged chain link fence still needs to be repaired. It is my recommendation to give them 30 days to correct all remaining items. If not, a per diem fine of $500 and $100 admin fee. And I also wanted to add that I did speak to the property manager, and because the damaged chain link fence is adjacent to another community, the trunks of those trees that are there are actually damaging the fence. But this is something that the adjacent owner and the property managers have to work out together. Code does not get involved, but I try my best to get them in communication.
Okay. Yes, ma'am. Your name, please.
My name is Catalina.
You better press the button there. There you go.
Just make sure the light is green.
My name is Catalina Montano, and I'm the property manager. And in regards to the fence, we are trying to work on it. But like as she mentioned, the trees are from the other property, and they're right in the middle where the fence is at. So at this point, if we have to get in contact with the other property owner, I think it's going to take us more than 30 days. Maybe we would need 60 days because it's a lot and it's a big tree. And it's not only one. There's like 3 or 4 that are right in the middle, and they are in the other side of the prop. Actually, they belong to their side, and they're leaning against our fence.
Okay. Do you have an objection to what you said, 60 days?
I said 30 days. And this violation was written back in January 26, 23rd. Had it been addressed around that time, that was about 4 months,
Okay.
In between that could have been resolved. I believe they started acting on it the moment that they received the hearing notice.
Okay. All right. I'm going to go with the 30 days. All right. If you need more time, then you'll have to ask for it from, okay, and you said 250 per day? Or
500 per day because of the
500, I'm sorry.
repeat offense relating to case 6731.
Okay, I've only got one order. This is case number 8109.
Yes.
That's 500 per day.
Mm-hmm.
Okay. Okay. I've listened to the evidence. I'm going to find there's substantial competent evidence to support the city's position. You'll have 30 days of which to comply, or 500 per day thereafter, after the 30 days. So take care of it. Okay?
Okay.
Thank you. All right.
All right. There's another case on the agenda. Same property manager. This is case 8593. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 8593. Property owner Pembroke Villas Apartment Ltd. Site address 4803 Southwest 41st Street, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent by certified mail 8/23rd, posted to the property and town hall June 9/23rd. The violation is for a damaged concrete and picket fence. Obtain plans for permit and complete all required inspections. This is a repeat offense relating to case 5202. It is my recommendation to give 30 days to comply, if not a $500 per diem and a $100 admin fee.
Okay. Your position on that? Go ahead.
Property manager. Question. We obtained the permit like 3 weeks ago, and we scheduled for inspection, and nobody has been there. So we haven't been able to start. But we have everything.
You have to ask the building department.
I came here and I scheduled a inspection, and no one showed up.
Okay.
To Mary, when I came to get I told her that we were ready, and we scheduled an inspection. I still have the permit in the office.
What inspection did you schedule? Structural?
Yeah.
But the fence is still damaged. Have you mean like a plan review? What?
I can't remember, but we got the permit, and I remember when we fixed the other fence, we had to do the same thing. Like, just we made the holes, and they were supposed to come inspect that we were ready to start putting up the fence.
Mary, do you know which inspection?
No, she can go to the building department. Jeffrey is in there, and he can check the system.
Okay. Catalina, so when things like this happen, if you can please email me so I can follow up for you and try to help you. But as far as the permits and what things are happening, I don't process the permits, so I don't know where you're at your permit. So it's something that we have to get building involved and work this out together. Okay?
Yeah,
So-
because it's, the day I got the permit, I came back the other day and I told her that I spoke to Mary and I told her that we were ready for inspection. And she said, okay, it's going to be scheduled for the next day. No one showed up. So,
Okay,
ready.
so we'll have to look into that
and
together.
also it's been raining every day. So,
Okay. I'm going to concur with the city. I'm going to find a substantial competent evidence to support the city's position, 30 days in which to comply, and $500 per day. Is that right? Yeah. Okay. Okay, thank you very much. Good luck to you. Thank you.
Next case is 8352. I have Abiola and Shana. Have you guys been sworn in? No. Okay, you're gonna give testimony for the case today?
Yes.
Okay.
I'll do it.
The-
You come on up and I'll just swear you in, okay? If you could just raise your right hand, please, ma'am, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If you could both affirm.
Yes.
Thank you very much, please.
You're welcome.
Let the city go first. Okay, thank you. Thank you.
You should have a seat or?
No, you may wait.
Yeah, sure, sit down.
I'll
if
be
you-
quick.
Sit down.
Whichever you prefer. Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 8352, property owner Josem 5401 LLC, site address 5401 Southwest 25th Court, Pembroke Park, Florida. A notice of violation was sent by regular mail, March 31, 23rd. A notice of formal hearing with a copy of the notice of violation was sent June 8, 23rd, posted to the property and town hall June 9, 23rd. The violations are for item number 1, silt on fence is broken and prohibited. Remove silt from chain link fence on back end of property. Item number 2, swale area is full of trash, debris, overgrown weeds, and dead vegetation. Remove trash, debris, dead vegetation, trim overgrown vegetation on back end of property. Item number 3, outdoor storage is prohibited. Remove all materials and store inside building on back end of property. Item number 4, swale area has bare spots and requires new sod on back end of property. Upon my reinspection on June 8, 23rd, there's not much trash. You know, periodically there's here small debris, but all the large trash have been removed. The silt is still on the fence. The outdoor storage is still outside. They did remove most of it, but everything has to be inside. And the swale area still has bare spots, so it does require new sod. I just want to say for the record, who we have here is the tenant. It's not the property owner.
Okay.
It is the property's owner responsibility, not the tenant's.
Of course. Okay. One or both of you, you're welcome to. What's going on?
Good morning.
Good morning. There's a button there.
It's on. It's
it
on.
is.
So it's
Great.
good.
Thank
My
you.
name is Fatima Shonde, and I'm one of the tenants because it's me and my husband's business. So when it comes to the fence, is that what you're saying? When we got there, it wasn't all covered up. Even though it told us we have to cover it up, we've done two different times to cover it up. As a matter of fact, over the weekend, we covered it up again.
No. The violation is you have to remove the silt.
Yes,
It's still on there.
So we're not supposed to have anything. It's supposed to be open, see-through.
Silts are prohibited. You can't have silts. What you can have is slats.
I'm sorry, ma'am. I'm just going to try to explain what I found there when we got there. So like the tarp?
Right.
That was what we found there when we got there.
That has to be removed. It's a violation.
So we're not supposed to have it?
No.
Show me the picture. You just told us we have to make sure it's there, and we just bought brand new ones.
Who told you that?
The landlord. So I'm sorry, man. Is it supposed to be like this? Is it how you want it to be? So you could see through?
Right. You have the option. It's an industrial zone, so you have the option to put slats. Our town ordinance gives you the permission to put slats, but not silt. What you have right now, it's like a tarp over the fence, and those are prohibited. So that torn silt has to be removed completely.
Can I show you this, please?
Yeah, you may show me.
Excuse me, please.
Sure, no, please. Let's go ahead.
Is this approved? Because we sent
No, that is not approved. That's a tarp, so you have to remove that. Can you return it?
I
No.
don't think they will accept it no more. Because on Saturday when we went back there, because of the rain, it blew it out again, and we have to go back again and buy another one. I even just asked him now before he got here, did he check? And he said he was trying to get you on time. So this is not permitted.
No. To correct the violation, all you have to do is remove it completely. You can leave it empty.
So it has to be see-through.
Yeah.
Well, the landlord told us we have to have it covered.
Yeah.
She can put that.
If she wants to, it's optional. You don't have to. If you want to easily remove the violation, just and the property, I'm sure, is holding you responsible for it because you're a tenant. So just to easily correct the violation, you just remove the silt.
Okay.
In the near future, if you want a little bit more privacy, you can put slats.
Okay. Okay, that's the first one. Thank you, ma'am. Then the second one is with the trash. I personally have asked my husband so many times, make sure that is not us.
That's a property next door adjacent, but all the trash goes on to your side. So everybody has to be in unison and clean up the trash on the swale.
Okay. Then we've noticed that, because sometimes when I go there, I'm like, Abby, why do you have this on the floor? And he's like, Fatima, people walk by and they just throw stuff. So on Sunday, it happens that I went there and I saw a guy repairing 3 cars. So my husband was like, this is exactly what I've been telling you, that people just take advantage of the spot and things are dumped there. I actually recorded him.
Okay.
I told him, I said, I'm recording you because it happens that we have to have a hearing today. So this is what I'm going through, and I'm now agreeing with my husband, because normally I'm always like, oh, why didn't you guys clean? I was like, Fatima, I picked up some stuff, but then before we come back, people are just walking by and throwing, and by the wind blowing everything, it just gathers up.
Okay.
So.
And then with the
You have to clean.
with the soil. Good morning. With the soil area.
I'm sorry, can you state your name for the
My
record?
name is Abiola Shonde.
Okay.
Yeah, for the soil area, the problem we have about the soil area in the back, construction people, their machine was parked there when they're doing the street for months, and they mess up the soil area. They park their machine there, and I don't know who the construction. Even I think Miss Ramirez too. One day when they want to come and inspect the place, she even told me that she can't get into the street because of the construction people are walking there.
Right, I believe the city of West Park was working on the roads and they blocked the roads.
Yes, but their machine was parked right there at that soil area.
Okay.
They do all kind of stuff on that soil area. So I don't think we should be responsible to do that soil area again, because when they're doing the construction at that place, they park their machine there for months, and all their big machine was parked there, and all that soil area, that's why it's like that. And then they do all kind of stuff with the construction, because they park right there at our soil area when they're doing the construction.
Interim attorney, what can they do in that circumstance?
give me 1 second to kind of take a look, because I also want to be where I can't give them legal advice.
Please, can I just ask you a question while is the attorney's check? So we are not allowed to have anything at all in the backyard?
No. Outdoor storage is prohibited. You have to store things in an enclosed area. So in the near future, if you need more space to store, you may want to look into obtaining a permit for a shed, and you can store it inside the shed.
I asked that question because that was part of what the landlord told us when we were renting, that the whole backyard is ours. And because we kind of moved in a rush, crunch time, I'm like, yes, that's a good deal for us that we could use the backyard. But then they did mention it that, like you said, it's not approved. I'm just saying what he said, that the tarp needs to be covered up so the city would not violate us, because they don't like the, like it it doesn't give the city a good look, which is true when they're all raped and so, it doesn't make sense. Like how it is, it doesn't look appealing.
Silts are used for construction purposes.
Okay.
Silts are for construction purposes. You're not doing construction, so you're not allowed to have them.
Okay. Thank you very much. Just one time.
And what type of business do you have there?
We have a party rental business.
Okay, because I believe I spoke to you. There is no business tax receipt, so that's another violation. And you said that you were gonna come in and take care of it, and I have not seen that.
I tried coming in even before you did the violation at all. And I think they said something about the water or something like that.
Have you submitted a business tax receipt application?
No, because
I urge you to do that today.
I will do it today. Because of the, is it something attached with the water or no?
It depends what type of business you have, but that's something you can discuss with Jeffrey Lewis at the building department.
Okay. Okay, thank you, ma'am.
Yeah, I think sometimes also you need to get a business tax receipt before you can do anything. So you need to take care of that. I mean, if you don't have one. So, you know, it's not that difficult, I don't think, you know, to do it. So whatever the town requires, that's what you need to do.
Okay, sir. Thank you.
Yeah. Any?
Mr. Hippler, if I may.
Oh, yeah, please.
Regarding the swale, it is their responsibility to maintain the swale, understanding that there are numerous vehicles that are parking on it. As far as your responsibility, what I would suggest is that you have a conversation with the town's police department to see what they can do to assist to address the situation. And also you can have conversations whether or not signs could be put up regarding, there's a lot of rules and regulations regarding the particular parking that would give the city the ability to take care of the issue. So at the very least, at the onset, I would have the conversation first with the police department to see what they can do to assist.
Thank you, sir.
With the SWA area, right?
Mm-hmm.
Right.
Thank you, sir.
Thank you, sir.
But right now, there's no vehicles parked there. Upon my reinspection, I didn't see any vehicles
In
parked.
the back?
Right.
Okay.
It's clear right now. Okay. But your question was, who do you hold responsible for the swale?
Yes.
So those are civil issues. We can't get involved. What you can do is probably seek someone from maybe the city of West Park who was doing the construction, or your neighbor who was doing the construction, and ask them directly, but we can't give you legal advice either. So
Right. It is your responsibility to maintain. If someone else is parking on it, using it, destroying it, then you might have a civil issue to take up with that town.
Okay, so please, I have another question. So how the building is, how the building is constructed, it has two entrances. Like, so we could go through 25th Court, which is the front door, and the soil area is, I don't know, what street is that? 5th Street? So in other words, you're telling us that every time we go there, we have to make sure we go on both streets to make sure nobody's parked there. Okay.
Okay, what's the recommendation again, since
since the swell area is clear and these are not extensive violations, my recommendation is 30 days.
okay.
And per diem of $250 if it's not corrected by then,
Okay, 30 days and 250.
with the $100 admin fee.
Right, gotcha. Okay, based on the testimony and the evidence it's been presented, I'm going to find your substantial competent evidence support the city's position. They'll have 30 days in which to comply, or 250 per day thereafter. Okay.
Please, can I please request for 60 days? And the reason is that means I have to get another storage unit to store the items in the backyard.
You don't have the space inside.
No, ma'am, we do not. And like I said, that was one of the reasons why we got the place. He said we have access to the back. So please.
The thing is that you have to go through a permitting process to get a storage there or build something.
No, I'm not. I mean, like to get a public storage, but then the funds, we're a small business.
Oh, to get
Please.
a public storage?
Yes, please.
I'm okay with the 60 days.
Okay.
Thank you, ma'am.
60 days, I'll amend that and say that 60 days in which to comply, or 250 per day thereafter.
But please try to take care of the easy things like the sod and the, making the soil look nice. Don't just wait for the.
So do we have to put the grass down? Is that what you're saying?
Right.
We have to?
Right. The property owner is responsible.
Okay,
Again,
so
you're not the property owner. Now, if your landlord is holding you responsible, we don't get involved in that. But we cited the property owner. I want you to understand that.
So how do we communicate this to him? Because he's a fairly older person. So sometimes it's kind of hard to communicate with him.
I can't give you
don't
legal
worry.
advice.
We'll talk about that.
Email him. Do you have a written lease?
Yes, we do.
Okay, that's going to set out what you're responsible for and what he's responsible for.
Okay, sir.
Okay, take a look at that and just email him. You use email, I'm sure. Does he or she, the elderly property owner, have email?
I would find out from him today.
Okay, just take care of it. Usually it's the property owner, but I don't know what your written lease says.
Okay, thank you, sir.
Okay.
We'll do that.
All right, good luck to you.
Thank
All
you. I
right.
appreciate it. Have a nice day.
Thank you.
Can I ask us a question?
Yeah. Just when you get up front, if you want to ask Charlene at the front desk for legal aid, they give you free legal service of what you can do in these type of situations.
Okay.
Okay.
Thank you, ma'am. Have a nice one. So does the 60 days start from today?
Yes.
Okay. Thank you. Have a nice one.
I know she asked about the slides. Can I show them slides?
Hmm?
They can have.
You can show her. Yeah. Try not to confuse her. Like, she doesn't have to have anything to correct it, but in the near future, if she wants to get something.
Okay, it can be on any
Yeah.
color, right? Any color?
No, forget it. Forget it. Yeah, I don't know about the color.
I don't know, you see you have the green, you have the page.
Okay, we have one more person in the audience. So we'll hear that case, which is case 7722. Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 7722, property owner Pembroke Park Warehouse Holdings, site address 3140 Pembroke Road, Unit 612, Pembroke Park, Florida.
Thank you.
A notice of hearing to extend time was sent by certified mail May 30, 23rd, posted to the property in Town Hall June 9, 23rd. The violation is for conducting business without a business tax receipt. As of March 28, 23rd, it has been marked non-compliant. The business owner is still working on the BTR. They have to pass fire inspections, which has been denied. So it's my recommendation to give them 30 days extension of time, and if not, the same per diem, which let me try to get that for you. I think it's 500 per day and $100 admin fee.
Okay, come on up here.
My name is Levi Horvath. I'm only representing, I don't know much about it. I don't know nothing. I don't know if it's enough 30 days or not enough. I don't know what to tell you guys. I just represent here the owner to be here because
Okay, well, then I appreciate that, but I'm gonna.
because that's a rental too, no?
Right. I did speak with the property manager, Nancy Romero. She said that 30 days would be sufficient time.
Oh, okay.
Okay, all right.
Thank you.
All right,
No
30
problem.
days. I'm going to find there's substantial competent evidence to support the city's position. They'll have 30 days which to comply, or 500 per thereafter if they don't comply. Okay?
Thank you very much.
Thank you. Yeah. Since there's no one else after
Thank
this
you. Have a
gets,
wonderful day.
You too.
See you guys.
we could just take a 5-minute break if that's acceptable.
Okay.
Sure. Yeah. You're not tired, officer?
We're gonna
You've
take
been standing the whole
a break,
time.
okay?
So.
All right, take a break.
Okay.
By my count, we only have 6 cases left.
Okay.
Okay. We're going to start the cases by the order of the agenda, starting with section 7.1, case 7159.
71.
59. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 7159. Property owner Carmen Yolanda Camano, site address 119 Lone Pine Drive, Pembroke Park, Florida. A notice violation was sent by regular mail, January 27, 23rd. A notice of formal hearing with a copy of the notice violation was sent by certified mail, May 26, 23rd, posted to the property in Town Hall, June 9, 23rd. The violations are for item number 1, installation of 2 sheds without a building permit. One of the sheds was existing, so we're removing that from the violation. She would need to obtain the permit for the recent shed that has been installed. Item number 2, started work without a permit, interior renovations without a permit. The interior renovations is a bathroom. We saw construction debris out there. She has not obtained a permit for that. And then item number 3 is installation of screen room without a permit. That screen room was existing, so we're removing that from the violation. My recommendation is to give her 60 days to comply, if not $100 per diem and $100 admin fee.
Okay, this is a no-show. They've been noticed. I'll fine within 162 Florida statutes. Based on the testimony and evidence, there's substantial competent evidence to support the city's position. I'll give them 60 days in which to comply or $100 per day thereafter. Thank you.
Next case is 8107. Same property owner. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 8107. Property owner Carmen Yolanda Camano. Site address 119 Lone Pine Drive, Pembroke Park, Florida. A notice violation was sent by regular mail, January 27, 23rd. A notice of formal hearing with the copy of the notice violation was sent by certified mail, May 26, 23rd, posted to the property in Town Hall, June 9, 23rd. The violations were for installation of 2 wooden steps without a permit. The property owner is working on getting homeowner permits for the wooden steps. However, I have not obtained a permit number or anything of it. I'm gonna give her the same amount of days of the previous case, which is 60 days, and $100 per diem and $100 admin fee.
So, based on the testimony, evidence, code compliance officer, I'm going to find there's substantial competent evidence supports city's position. They'll have 60 days in which to comply. Did you say $100 per day?
Mm-hmm.
Great. Per diem, and if there's no compliance within the 60 days. Thank you. There you go.
Next case is 8354. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 8354. Property owner Enco LLC, site address 5411 Southwest 25th Court, Pembroke Park, Florida. A notice violation was sent by regular mail, March 31, 23rd. A notice of hearing with a copy of the notice violation was sent by certified mail, June 8, 23rd.
Okay.
Posted to the property and town hall, June 9, 23rd. The violations are for item number 1, soil area is full of trash, debris, overgrown weeds, and dead vegetation. Remove trash, debris, dead vegetation, and trim overgrown vegetation on back end of property. Item number 2, soil area has bare spots and requires new sod on back end of the property. Both items still exist as of my reinspection June 8, 23rd. It is my recommendation to give them 15 days, if not a per diem of $250 and an admin fee of $100.
Okay, I'll listen to the evidence. I'm gonna find there's substantial competent evidence to support the city's position. They'll have 15 days to which to comply, or $250 per day. I'm also gonna find that they've been duly noticed under 162 Florida statutes. There you go.
Next case is 8595.
Excuse me. Can we wait 1 minute so I can print again the case 5595 because I missed 2 cases and I did it wrong, so my bad, I'm sorry.
Okay.
Can I print it again? So just
Do you just want to make a notation and we'll fix it at the end?
all right.
Do you prefer that, Mr. Hippler?
Whatever, I'll wait, no big deal. Okay, whatever your pleasure is. What's easy, what's easier?
I confused the case 5585 with the case the case 8595 with the case 8352.
Okay. So you,
Mr. Hippler signed the case 8595.
oh, okay.
You know,
All right, so we'll wait 5 minutes?
just 1 minute.
Okay.
All right.
Thank you.
But take the papers with you just in case.
I know.
Okay.
Thank you.
Great. Okay, Pembroke Park Villas LLC, 8595.
Yes, yes.
Okay. And which one is this?
This one is the 83, and we have to, 60 days and 250.
Okay, but in this one?
And this one, she didn't present.
Oh, she's present, okay,
presented,
so
so
I
we
didn't
can-
put the days here, so,
If you want. Want this one?
uh,
I explain
I'm
it?
sorry, 8352, is that one? that-
If you want, give me that.
Yeah,
Give me that, and I'm gonna explain you at the end.
yeah, okay, great, go ahead. All right, at the end, thank you.
All right. Next case is 8595. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8595. Property owner Pembroke Park Villas LLC, care of Pickett Law Firm, PA, site address 4945 Southwest 41st Street, Pembroke Park, Florida. A courtesy notice was sent by regular mail, May 30, 23rd. A notice of violation with a copy of the notice of formal hearing was sent by certified mail, June 8, 23rd, posted to the property and town hall, June 9, 23rd. The violations are for item number 1, soil area is full of trash, debris, overgrown weeds, and dead vegetation. Remove trash, debris, dead vegetation, and trim overgrown vegetation. Item number 2, overgrown tree, trim and prune overgrown tree. Item 3, soil area has bare spots and requires new sod. And then this is a repeat violation referencing case 6829. Since this property is vacant, I would like to state for the record that if the property owner does not correct this violation within 10 days from today, then the town will go and clean up the property and the property owner will incur the cleanup cost fees. And if the property owner fails to correct this within the 10 days, then a $250 per diem with a $100 admin fee.
Okay, I can write that into the order because it just
Okay.
merely says within 10 days there should be held on compliance. So, and I can asterisk it in the will, if you will. So,
It is written on the violation. I don't know if that helps, but just wanted to let you know.
okay, and so give me some nice words that if owner fails to comply, then town will comply and assess property with costs. How about if I do that? Which means you can lien the property, so. Okay, you have 10 days, $250 per day. You said $250 per day?
Yes.
Okay. Cure violations and charge owner all. When I'm asterisk, and I'll initial it off. If owner fails to comply within 10 days, town is authorized to correct and cure the violations and charge the owner with all attendant costs and impose lien. Okay, fair enough. I've written in before, so, and I've signed off on it as well. All right, very good. That's in case number 8595. Thank you. There you go.
And just for the record, because the city and the abatement was granted, it's a health, safety, and welfare violation.
Okay. Next case is 6926. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park case 6926. Property owner Racetrack Petroleum Inc. care of Silver Oak Advisors. Site address 3031 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail May 26, 23rd, posted to the property and town hall June 9, 23rd. And it is the town's motion to confirm the fine of $43,600 and the property is in compliance.
Okay, I'll confirm the fine for $43,600 in case number 6926. There you go. Thank you.
And that concludes all my cases.
Okay. Very good job as always, so,
Likewise, we have a good team.
yeah.
Okay, Mr. Hickey, let me
Yeah,
explain.
go ahead, show me what I need to correct here,
Okay.
so.
When they called this case, I
Yeah.
gave you that paper, yeah? So
Yeah.
you fill out that paper.
Yeah,
And this is the good one.
okay, so.
So
you-
we have just to, you have just to write what you wrote here. You have to write it here, you know what I mean? And that's it.
Oh,
And we have to destroy this paper.
Oh, destroy this.
Yes,
Okay, so this is the correct
This
one
is the
then.
correct one,
Okay, got you. Okay, all right, 60 days. All right, very fair enough.
And
Okay,
here you can put like yes and your initial.
initial. Okay, yeah. Or yeah, he was
The
here.
word, yes.
Okay. You get rid of this then. Right?
Thank you.
No,
And,
thank you. It's okay. Look,
My bad.
nobody's perfect, you know. No big deal.
Thank you very much.
That's all right. Oh, okay, we'll conclude the hearings. Any further business? Okay, very good. Thank you.
All right. Item number 11, adjournment.
Yes, oh yeah.
Okay, at 11:41.